So a court case will start with a notice that looks like this. They all look like this because this is a court-created form. And when people get this, they generally look down in the bottom box here, and they notice that it says, notice to each defendant, tenant, occupant at the hearing on, and it literally has a space where they fill in what date the hearing is on. But the important thing about this notice, because an eviction case, which is called summary process, runs differently than all other types of legal cases, because it's a foreshortened process, is the date down here at the bottom that says answer date. This is the critical date that you've got to capture. It's before the first hearing. When someone sues you, you have a right to answer their lawsuit. And that's what that date is, for you to give a written answer to their lawsuit. The other thing you use that date for is discovery, which is your opportunity to ask them for the documents and evidence they're going to use to try and beat you. Okay? So that's often for people the first time they get a chance to get their hands on the documents that the bank has been claiming validated their right to first foreclose on you and now try and evict you, right? Because they can't evict you if they can't prove they own the property, right? Now, you're all nodding like that's obvious. Just so you know, a lot of the judges haven't wrapped their brain around that yet. That they can't evict you if they can't prove they own the property. And that's especially true for tenants as well. And a lot of the judges are acting like, well, tenants don't need to have a right to know who owns the property, which is ridiculous. We actually had a member who had an ongoing owner of the property who she had a rental agreement with, who she was paying, and the court decided she wasn't allowed to argue that that party owned the property, and then the court demanded that she pay the bank as well, and of course she couldn't afford to pay both. So it's clearly not correct under the law, and it's clearly not fair to people. So you need to capture that date to file your answer in discovery. The other way that people get information before going into a court case is to file a qualified written request. This is a letter that you're allowed to send to the party that was servicing your loan. In other words, the one that was sending you the bills. The party that was sending you the bills has an obligation under your mortgage, under federal law that is called RESPA, R-E-S-P-A, to answer your questions regarding the loan. And there's a really fabulous letter from the Consumer Finance Protection Bureau, so you don't have to write it yourself, that you can send, and there's a link on our website for getting that letter. So you walk into court either with your information from the qualified written request or because you timely filed your answer and your requests for discovery from the other side. There are very good answer and discovery forms that are created by and updated by legal services in our state, and those are the ones we use. So again, you don't need to be intimidated about it. There are check boxes, and somebody who knows how to fill those out can fill them out with you relatively quickly and make sure that you ask the right questions for your case.
So yes. When do you do this qualified written request?
You can do it whenever you want. A qualified written request can be sent up until a year beyond the ending of a servicer for your loan stops servicing your loan. So in other words, if you get a turnover, you get a notice saying it's no longer AMC that's going to be servicing your loan, it's now Bank of America, or it's no longer Bank of America, it's Ocwen. You have a year after that you could send a qualified written request back to Bank of America, okay? You can still send one to Ocwen, who's billing you right now, whenever you want. But that also means that if there's been an auction, you have till a year after the auction that you can send the qualified written request, because that servicer was your servicer for the mortgage up until the auction. So there's a lot of time, space when you can do it. I believe there's a limit to how often you can do it. So I think if you do it more than once every 6 months, then they aren't legally obligated to answer you. But you can still send it. Anyway, back to the court case. So this notice that I was showing everybody is sent to you not by the court. It will be sent to you by the bank's lawyers, whoever they are. Always open your mail related to the court and related to your court case, because Summary process, because it's shortened, it's summary, goes very fast and you can easily miss a date. So always open your mail. The answer and discovery forms you fill out, as with almost everything you ever do with the court, you always get 3 copies. One for you, one for the court, and one for the lawyer you're up against, okay? And you are responsible whenever you put something into the court to also send it to the lawyer on the other side. If they put something into court, they are responsible for sending it to you as well as to the court. So there have been people who've thought, oh, I'm in a court case, I only need to open the mail from the court. The court is responsible for a very small percentage of the mail that you will get. So always open everything that comes, and expect that most of the things that happen in an eviction case, you are either going to schedule them and notify the other side, or the other side's going to schedule them and they're going to notify you. The steps in a court case for summary process, which as I said are not in the same order for any other case. Answer discovery is due first. There is a hearing that is scheduled on here, okay? This hearing will automatically be put off by 2 weeks if you timely put your answer and discovery into the court and serve it on the other attorney by the deadline, okay, which is down here at the bottom of the box. That court date moves 2 weeks because you've just asked them for a whole bunch of information. They have 10 days to respond to that. So the case had to move 2 weeks so that you would get your response before the case moved forward. And in fact, until you get your response, no matter how long they take, the case is supposed to not move beyond what's called the discovery phase. It stays there until you've got your discovery, even if it takes months or years. And they are supposed to have served you, if they were going to ask you for questions, by the same deadline you had, this one in the little box here. They usually don't, and then they go to the judge and, well, sometimes they'll just send it to you and act like you have to answer it. But if they're late, you don't have to answer it unless a judge tells you to. Okay, so then they'll go to court and go, oh, we didn't know they were going to ask us questions, so now we want to ask them questions. Mind you, these are the richest banks in the world, and they've hired lawyers. They can certainly follow the rules. If you can learn the rules and follow them, they should be able to do it. Anyway, it may get postponed several times while you're waiting for your discovery. And reschedule hearing, reschedule hearing, reschedule hearing. When you check off your boxes in the answer and discovery, you will also check off that you want a jury trial. You may not want a jury trial, but under U.S. law, you have to ask the jury at the beginning of a case. You can't ask for it later. You can give it away later if you don't want it, but you can't ask for it. So we always recommend everybody check that off. Just to protect yourself, because among other things, they have to impanel a jury to take you to trial if you've checked off the jury box. If not, they can surprise you one day. You get into court and you think you're doing a hearing on your motion to compel discovery that they didn't give you, let's say, and the judge says no and then says, oh, and let's start the trial. But you weren't ready. So the jury, checking off the jury trial also protects you, because it means there's a certain amount of lead time they would have to give before you're going to end up in trial, okay?
How does that relate to the redemption of your home, all of this process?
Well, they have to prove, all right, so they're the plaintiff. They have to prove their case. Their case includes proving that they own the home. If they fail to prove that they own the home, if you can punch enough holes in that, then you're still the owner. Okay, now you have a court ruling saying that you have a right to stay in the home because they don't own the property. Okay, so that's how it relates. And if you fight well, they sometimes then offer you a loan modification, or you might postpone it enough so that they agree to let you buy it back rather than continue the headache in court. So it's any of those things can be why this is when you finally get your shot at the house. Okay. You've asked for discovery, maybe they've asked for discovery. The next thing that will happen is there will probably be some hearings on motions. You might put in a motion, they might put in a motion. After discovery is done, they may well decide to short circuit your shot at a trial by filing a motion for summary judgment. Now, summary process was not really set up for summary judgment because it's already shortened enough, but summary judgment tries to shorten it even more. So if you go to trial, a trial covers 2 things. the facts about what happened, looks at the evidence about what happened, and any legal argument for interpreting that evidence, okay? If they go to summary judgment, what they're saying to the court is, there are no disagreements about the facts. We just are going to have a few arguments about the legal interpretation of those facts, and then you can make a decision. Now, our fight is almost always the facts. They're not telling the truth about what happened. And it's your facts, your documents, your evidence that's likely to make you win. So if the judge takes it to summary, allows them to take it to summary judgment, that's a problem for us. You're not necessarily going to have a lawyer. The vast majority of folks end up arguing these things themselves, and people have won cases all the way up to the top court in Massachusetts, having done their argument without a lawyer. So it's intimidating, but people do it, and some people do it phenomenally successfully. So don't panic about not having a lawyer. You do need support, you're going to need information, you're going to need a chance to practice. You have to be willing to read a lot of stuff. But we all work together, so you're not alone with that. So you have hearings. Sometimes that's a good thing. That's practice for you in front of the judge. So you get some practice under your belt before you have to get into the real serious arguing. So they may try and take you to summary judgment. If they don't, you're going to have a trial. And then if you've watched TV, trials on TV aren't that different from what a trial is going to be like when you're in court yourself. So you may have gotten some sense of what's involved. And if you do a jury trial, or if you don't give away your jury trial to the last minute, there will be a step between whatever motions are heard and the trial, and that's called a pretrial conference. A pretrial conference is not, and whenever you see conference, status conference, pretrial conference on a notice, that is not a time when anybody's going to be arguing anything. You don't have to go in prepared to fight. It's just information. To set up a trial, a judge needs to have some clue how long the trial is going to take. So a pretrial conference, which you usually walk in with a fair amount of written information, is just to tell the judge how many arguments are there going to be, how many pieces of evidence are there going to be, how many witnesses are there going to be, and that's just their way of trying to figure out how much time to allocate. So you don't need to worry about it. Meet your deadlines, but you don't need to worry about it. And then there may be a trial. Whether you get a decision out of summary judgment or out of a trial, people often win by appealing. So again, don't panic. The judge doesn't like you, they're being a jerk, they haven't let you put in what you needed to argue, blah, blah, blah. You're going to appeal what they do if you don't like it. And if you're indigent, which most folks qualify for at this point because everything's been stripped if they've taken the home, you don't have to pay for the appeal either. It's just a matter of doing work. And people often get intimidated about an appeal. They're like, oh my God, you know, court was bad enough. Now I'm going to be at the appeals court. Actually, you don't usually talk at appeals court. It's just writing stuff. So there's a way in which, as long as you're willing to slog through the paper, it's actually less stressful than the court where you have to appear and talk and be up in front of a judge. An appeal is based on the evidence that you put into the in this case, housing court, the lower court as it's called, or the trial court as it's called. So what's critical is not that the judge agrees with you. What's critical is every argument you want to get in there, every piece of evidence you want to get in there, you get it in there. And if they disagree with you, it doesn't matter because the appeals court will review whatever you got into the file. So that's the trick in court, is to make sure you get everything in the file. And then the appeals court does not actually rule on your case. What the appeals court is doing is ruling on whether the judge did the right thing or not. So the way you argue things changes a little bit, but it's still the same process, basically. All right, so I think...
So, in fact, if one does have a very complicated case that does date back, one wants to get as much of their complete information as the defendant of all the evidence they have.
You want to get every piece of evidence you have into the record. That's critically important.
After that summary process or whatever, then you cannot enter anymore.
It gets complicated. There are lots of ways to do stuff if you really need to, but our goal is to keep the most critical thing is don't miss a court date. don't ever miss a deadline, don't ever miss a court date. As long as you do that, the eviction rules are set up so that they can't evict you while the court case is going on. So as long as you meet all your deadlines, then, and if you're ever gonna miss a deadline, say you're sick, right? Or there's a crisis in the family, you can't meet a deadline, you get something into the court. A note saying we need more time, please give me an extra week, whatever. Always get something in by the deadline. But you'll have other options. So say they jump to summary judgment, you weren't prepared, you don't have all your documents. You have a right to ask for reconsideration, and if you do it timely and you do it the way you're supposed to do it, then you get all your documents in when you ask for reconsideration. So there are several opportunities to do it. And so the trick is that during the time between, usually after the auction, supposed auction, that will turn out not to have been legal, you have time to gather documents and to learn your case, and we recommend that you start learning as soon as you can. Everybody's style is different, and it takes people a different amount of time to learn stuff. Some people do better. The reason we're doing these videos is some people do better learning by video than in writing, whatever it is. It just helps to get started early, and it's been a horrifying road to get to this point. People are usually exhausted. It's been disempowering, it's made you feel hopeless. Somehow you got to get past those feelings enough, because now finally it may be your chance to step in and get some control about the timing of things and choices about how the information gets presented, and you haven't had that for years. So somewhat you need to change your mindset to get yourself to a place where you can be effective and use the information that you've got to the best of your advantage.
What if they only offer you a short sale?
Okay, let's...
I'm sorry. Oh, was he?
That's not about court process. I know that's not about court process. Yeah, I don't want to deal with short sales right now.
Okay.
Ask it at the next meeting.
I sure will.
Okay. When is your, you've had the auction?
Yes, the auction was 9/20.
All right. So ask it at the meeting. We'll deal with it. I don't know that we're going to get to short sales day. Maybe we will, but where are we, my dear? Oh, you're giving it to me.
Our circuitous route.
Well, we did reading the eviction court notice, so that we already
Yep.
did. Check that off. Where did we do that? You numbered these, so this is part of number 7.
7A.
7A. Okay. Answer discovery, scheduling. Folks want to stay on court stuff?